and C, so I'm just going to assume we're good.
Okay.
All right, so you are all set. Go ahead. Just you can advance with the numbers.
Here, let me just housekeeping real quick.
Yeah, go ahead.
This is Andrew in Denver, and we've got Ben and Matthew here from WilmerHale. For those of you out in the other locations, for those of you in Denver, it's the sheet you're looking at here is something they put together. For those of you out in the other locations, there's a sheet on intellectual property overview that they've provided to us. If you have questions, please have the event managers type them up in legal, and if we have time at the end, we'll have them answer them live, and then if not, we'll make sure that we connect folks after they're done. So thank you both for being here. Really excited to add this as, again, something else to support the teams as early as we can. Thanks, guys.
All right, thanks, Andrew. So as Andrew said, I'm Ben Fernandez. I'm here with my colleague Matthew from WilmerHale. And we have some slides today. They're not real text heavy, so hopefully we can just open up a dialogue, and at the end we'll certainly take some questions and talk through some hypothetical scenarios that I'm sure you'll develop as we talk today. So the purpose, and thanks again for having us here today. This is kind of fun for us. We're both intellectual property attorneys. We do patent litigation. We do the occasional trademark, copyright, licensing matter. We help companies buy and sell their companies or their assets, including intellectual property. So it's fun for us to talk folks through this. And I know you're probably all at different levels. I can see the audience here in Denver. Raise your hand if you've ever been an inventor on a patent before. One, we have one. Okay, so that's about the right statistic, I think, for people involved in coding. It's not a real common thing to be involved in patents, but when you are involved in it, it's an interesting, it's a long road, it's a lot to digest and understand. Today, our goal by the end of this talk is to have you guys understand the difference between patents, trademarks, copyrights, trade secrets, and also we're going to cover some of these legal concepts like how to form a company and how to minimize risk and how to deal with some of the higher level issues around IP when you're starting out. So this slide, I've actually done talks where I've spent an hour on this one slide, so this is a good place to start. This is a nice table that kind of illustrates the different main genres of IP and provides some examples of what those are. So let's talk through this. So patents are the ones that we hear about most. We're both patent attorneys, and patents are what help protect ideas. If you thought this, think about real property. Think about when you own a house, you own a piece of land. Real property laws, that's what help you maintain control over your property. It allows you to prevent trespassers from entering your property. Now kind of think about intellectual property. It's a little more abstract, but it's very similar in many ways. This is the law that protects people who invent things or who come up with new ideas. And these laws tell you what do you need to do in order to own that property right to prevent others from trespassing on that property right. So we're going to focus on the intellectual, but there are a lot of parallels to real property, and hopefully we'll draw some of those analogies. So a patent is like, you have to invent something new. It has to not have been done before. It also can't just be something that's kind of an obvious combination of a couple things that have been around. So, you can't invent, 99% of it is already there before, and 1% is just something you found in a textbook and put those together. It usually takes more than that to make something different enough to be patentable. But think of it like a fence. A patent is like using words to create a fence to say, this is what we own. The scope of my fence, it's big enough to cover what I've invented, but it's also not so tiny that it's easy to design around. So you can patent software. Software is patentable. Usually you see patents on things like devices, machines. There are different kinds of patents that we'll talk about, but patents protect ideas. Taking a step back, why is this important for you guys? Why is this important for startups? Well, think about if I'm an investor, I'm going to put some money into your company. If I pump $50,000 into your company and immediately someone down the hall is able to just copy it wholesale without all the same work that you put into it, my investment just disappeared because people are just kind of getting around it and using the same idea without putting the work into it. So think about it from an investment perspective. Think about it from a business development perspective. These kinds of rights are what allow small companies to expand geographically, not just in the US, but worldwide, by obtaining these rights that are like property rights, but they're in this intellectual realm. So patents protect ideas, and one example is the mobile phone. I mean, there's probably thousands and thousands of patents on my iPhone that I'm holding here. I probably shouldn't talk too much about that because my firm represents Apple. But there are lots of patents that protect a lot of different things, and patents are limited in time. Trademarks, you've heard of these. You know, when you think of when you hear Coca-Cola, you know where that comes from. And Matthew here is drinking Coca-Cola in the Denver location. When you see that can, when you hear the name Coca-Cola, you know which company that comes from. You know what to expect, and you know it's going to be consistent. That's what branding is all about. In the space that many of you are in here for this challenge, in the app space, branding is often the most valuable type of IP for a new app that's launched, because when it catches on, when it becomes popular, when you get a ton of great reviews in an app store, people associate the name of that app with being the real thing, the one that everyone wants, the one that works well. And trademark rights come into play when you need to shut down the copycats, you know, the ones that call it to litter instead of Twitter. You know, those kinds of copies on branding can be stopped using trademark rights. Copyrights. This is another type of intellectual property right that's very different from the other two. Copyrights protect creative works, things like movies and books and sculptures. You know, think about how long it takes to write a book. The author needs some protection there against just blank carbon copying, especially in our digital age where all it takes is a split second to make a complete perfect copy of a movie or a book. Copyrights are what allow the author or the company that owns that work to stop the copying through the law as opposed to through technology. We're reaching, I wrote a paper a long time ago on this, we're reaching the point where technology may actually be closing that loophole, and so things with encryption and digital rights management may make it easier to prevent unauthorized copying, but we still have the law of copyright as a way to kind of stopgap that kind of massive cutting and pasting. So copyrights protect expressions of ideas. Copyrights do not protect the idea itself. That's the realm of patents. So, you know, just because J.K. Rowling wrote the Harry Potter books, that doesn't prevent me from writing my own special Wizard Boy story about castles and schools. So, you know, the copyright doesn't protect the idea, it protects the expression of the idea, the words, the creative elements that go into it. The hurdle is pretty low though. So you'll see I've listed the software as an example of copyright that can be protected. If there's only one, you know, if there's only one way to write a line of code, that's pretty functional. You're not going to be able to protect that with copyright. But if you've arranged the code, if you've provided some comments and notes within the code, those kinds of things are all creative enough usually to get some type of protection. And what that does is it allows you to stop others from ripping it off wholesale. Trade secrets. This is the fourth category on this table. Trade secrets. These are secrets of a company, basically. This kind of law protects your company when someone decides they want to walk out the door and use all the proprietary, confidential information that you've built up as a company, and they want to go and use it to compete with you by taking it. And so the threshold here, we'll get a little more into this later, but trade secrets are things that are not generally known that you've taken steps to protect. So if a business that, you know, all of your revenue comes from the fact that you've got a great customer list and you know how to reach out to those customers and you've got easy access to that list. If someone walks away from that company and takes that customer list with them, that may be an example of a trade secret violation that could be stopped with the courts, even if technologically they were able to extract it from the company. And then finally, agreements. Agreements are the things that fill the gaps between all these other types logo is more of a trademark because you're using that logo. It's almost like a word mark, like Coca-Cola, right?
It's a mark.
It's a mark, yeah. So exactly. So when you have that logo, you're starting to get this association in the minds of consumers that when they see that logo, that comes from your company. So that is a trademark thing, and you can file and protect on logos, the actual words themselves. Yeah, and so in the standard, and we'll get a little more into trademarks, but the standard there is it going to confuse consumers? So for trademarks, they don't have to copy it exactly. I mean, you see this all the time. Is, you know, if you've ever traveled to, I see this a lot when I travel to Asia. You see, you know, marks that are almost exactly the same, but they change a letter or something, and that's usually going to be confusing for consumers. So, so yeah, that can be protected.
I think it's interesting is when the marks are completely different, the words are similar, and they're in two different industries. They say, well, it's confusing. I've never quite figured that piece out. That's why you get attorneys, I guess.
Yeah. So the comment was about, you know, the marks that are kind of similar, but they're in completely different industries, and you know that is the realm of attorneys. We help companies wade through those because the law itself is actually kind of gray when you get into some of those areas. Like, you know, if they are totally separate industries, and I can't really think of one off the top of my. Delta Faucets and Delta Airlines, two completely different companies. Thank you, but because they're in such different businesses, they're able to both maintain rights in that Delta trademark. So it's a great question. And we'll cover a little more about trademarks here in a minute. But design patents are, think of it, and these only last a certain amount of time, so think of it as you've designed a product. It's the shape of the product that makes it valuable as opposed to something how it works. So back to some of the patent basics. Timing is really important. If you're going to file a patent application, you have to file it within a year of your first public disclosure. So what does that mean? If you go live, you've started a clock with your code where you only have a year to actually file a patent application in the United States. Or it's not just going live. If you publish a paper, if you publish an article that describes your software or puts pieces of it on, you know, if you put pieces of it on GitHub without any kind of other, you know, protection or shielding or encryption, that can be a public disclosure, and you've started a clock where if you're going to get a patent, you have to do it within a year. And here's the tough part for startups. Most other countries don't give you that year. So if you want to preserve your rights to file in other countries for patents, this is limited to patents, you have to file your first patent application before you start showing people, you know, outside of your team that has confidentiality, before you start showing people. And that's a huge hurdle for startups because, you know, filing a patent application is usually not cheap. So timing can be important. If something's been out there for a year free and clear without being filed on, it's public domain in terms of patents. And the reason here is, if you think about it, it makes sense. You can't let people build up some rights in something and then file on it 5 years later, because, you know, it's otherwise everybody would do that, and we would all be gazillionaires, and it would bring commerce to a halt. You have to file, if it's a good idea, you have to file on it within a certain amount of time. That's just what the law says. This third bullet point, this is a huge concept, and I would actually say most investors that I talk to, I would say half of investors, even sophisticated investors that I talk to, don't fully understand this third bullet point. Patentability, just, you know, the ability to patent a new idea doesn't mean that that idea is free and clear of infringing other people's patents. So I'll go more into this. So you know, there's this whole set of law over what does it take to get a patent. Like I said, it's got to be something new. It's got to be something that's not obvious, or an obvious combination of some existing patents or existing ideas. But you know, you go through that process. You decide, can I get a patent? On the freedom to operate side, though, this relates to when you actually launch your product. Are you going to infringe someone else's patent? So think about this. I mean, if I have a water bottle, you know, I might patent a new shape or a new function on the water bottle, but someone else, when I launch that product, someone else might have a patent on the material, the chemical composition of the stuff it's made from, right? So the fact that I got a patent on my water bottle doesn't mean that I'm free and clear of infringing that other guy's patent on the chemical itself. right? So these two concepts are completely separate. And when you're starting out, you're not about ready to launch something, and even if you are, you're probably not going to be the target of a multinational corporation that's going to drive you into the ground. The freedom to operate type stuff comes along when you're hitting the big time, when you're getting investments, when money starts to flow in. Patentability, though, that's something that you can start thinking about early on here, because often patents or intellectual property in general, that's the main asset of a startup. It's your ideas, right? You don't have factories, you don't have employees yet. Maybe you have a few, but ideas are what you own. Did you have patents and software? This is my last bullet point on patents. So software is patentable. It's become much more difficult to get a patent on what we would call software. There's been this public outcry over what are called patent trolls or non-practicing entities, and it's become more difficult to get a patent on something that's really just something happening within a computer, right? You're just describing what's happening in the code. The patent laws are shifting more towards, okay, we're looking for some kind of a real world physical application, or we're looking for some kind of leap with how the code is interacting with hardware, or something that's happening in the computer that's fast enough and new enough that it just can't be done in real life without the computer code that's been developed. So I say that because when you're a startup, you really want to think carefully. Even if your idea is new and it's maybe patentable, it's not always the best approach for protection. So I showed these slides on utility patents and design patents. Any questions on patents before I move on? It's tough for me to move on so quickly from patents because that's what we do a lot, but it is important that we cover these other IP concepts. Any questions on patents? Yes?
You said a lot of small companies don't do this because of the cost. Ballpark.
Ballpark for a software patent these days, I would say $12,000 to $16,000. And that's, you basically hand it to them and they do everything. You can actually file what are called provisional applications for very cheap, and you can do it yourself. There are resources. I think on the bottom of our handout there's a pointer to the US Patent Office, and they have inventor help resources. And most of the expense there, though, is paying the attorney, right, to help you do it right. The actual filing fees are, $260 for a microentity or something like that for a provisional. What I will tell you, though, when I'm representing investors or the buyers of these assets, I can tell immediately whether you filed it yourself or whether you had, the Wilmer Hale of the world prepare it for you, and so there's risk there.
Totally. If you do the cheap one yourself and totally screw it up, do you have the option at that point 2 years later to go back and have a lawyer do it? Like, does that buy you time? Like, does that get you into that?
No, unfortunately, you may have an option within that first year as to the United States, right? Because we have that 1 year grace period. But there are things you can do in that first filing that can actually hurt and make it impossible for someone to fix later on. I mean, I don't mean that to sound too scary, but like I said, I can always tell if somebody says, my invention is never X, right? Like the word never, when I teach my patent students how to draft these, I actually do a search for the words never or always, or those absolute words, because that can just really destroy the value of a patent, even if it gets fixed later on in the process. So it's a great question, though. I mean, it can be expensive, and that's why if most of your value is going to come from being known for your app, the branding may actually be more valuable early on than patents. And we file patents on apps all the time. They're just really tough to get, especially now, because there are so many, even prior filings on apps, right? It's usually not enough to say, well, I'm doing the same thing as this other app, but I'm doing it in a whole different industry. The patent office just says, well, from a technological perspective, it's the same thing. It doesn't make it patentable that you're kind of
Example of another travel site then like Kayak uses a totally generic word but in a very creative way. And are they then able to trademark that as well?
Exactly. So the question was like the example being the website Kayak, and are they able to trademark that? And it is creative, yes. I think the answer is yes, but if they were to start selling kayaks, they couldn't stop someone else from using that term to sell kayaks. And I will say too, as the market's famous, and this isn't just like, known, if the market's famous, there are some special protections that apply to that, like, McDonald's or Coca-Cola. The famous brand owners are able to stop the use, even in markets that don't have a lot to do with the markets that they're in, because they're famous, right? So if I tried to sell Coca-Cola, thumbtacks, Coca-Cola could shut me down, even though they're not in the business of thumbtacks. Another question?
Yeah, I'm sorry.
That's all right.
If you try and put together a name and a mark to create something unique, can that be trademarked in its collective state as opposed to somebody saying, what you is digital and garage are generic terms, but with the mark you create something unique. Can you create that so that the items themselves or the collective entity becomes trademarkable?
Right.
Not, even though individually they may not be?
Yes.
I'm asking right.
Yeah, no, the answer, the answer is
yes.
yes. Yeah. So the question is, can you kind of combine two words that may not themselves be protectable to create the combination of the words, or the word plus the logo is protectable in the trade dress sense? And, digital, an example given.
And they turned me down.
Right.
Of course, I'm not an attorney, but
Right. So I won't comment on your specific situation, but in general, it is possible to do that. And they'll still look at the entirety of the trademark to see, is it going to confuse consumers, right? So I can't have a Coca-Cola Fernandez and try to get a trademark on that, because it's going to confuse people into thinking, even though it's got my name tacked onto it, it'll confuse folks into thinking I'm somehow related to Coca-Cola. So, but it's a good question. There's a lot of gray area. Another question.
Just clarification. So you said that the famous markets, Coca-Cola, McDonald's, they can shut you down. But why? Because they're so dominant in their powerhouses, or what's
Well, great question. And this trademark stuff all goes back to, these are laws designed to protect against consumers getting confused, right? So it's all about, if I as the consumer go to the store and I see McDonald's, graham crackers, I'm going to think that's probably related to McDonald's. I mean, they sell food. I'm sure they've just gotten into graham crackers, so I'm going to trust McDonald's graham crackers just like I would trust the restaurant, right? So it's all about, is the consumer going to be confused? And the spectrum of descriptiveness, the importance of that is that the words that are generic, that you need to use, those aren't going to get protection. But things that are more creative, like Kayak and Trivago, and even like when Apple computers first came out, and again, we represent Apple, but when they first came out, Apple didn't mean anything related to computers. I mean, maybe you've got bytes and whatnot, but that identity of the brand has been built up over time. Yeah.
So you talked a little bit about how you can protect yourself. Can you talk a little bit about how you can make sure you're not violating other people's trademarks? Like what's a reasonable due diligence before you go out?
Great question. So the question is, what should you do to protect against threats from outside, from third parties, before you launch your trademark? What are some things you can do? You can actually search the U.S. Patent Office website, and I think we provided a link to the USPTO on the handout. You can actually do some searching yourself and see what's out there. You can Google the name that you're about to use. These are all kind of informal ways. Now, when you're going to really put some money into this branding and you're ready to launch, it often makes sense to consult with an attorney. This process is much less expensive than patents. I mean, you're usually looking at between $500 and $1,000 to have them do a full search and give you full advice on whether it's free and clear. The downside to that, though, is sometimes you run into a problem and your attorney says, look, you can take this so far, but one day you're going to get that letter and they're going to want to shut you down. And so at that point, sometimes companies say, well, let's go back to the drawing board. Let's find a new name before you sink too much money into it that you're kind of stuck with it. It's good to think about, is it really unique? And I would say if your name is already intended to be something similar to a big company on purpose, that's usually an indicator that you need to find a different brand, because you will run into those problems. There are some, like for the famous brands, even small little violations can trigger action because they're very vigilant about that. But it's a great question. So you can do a little searching yourself and get some sense. And of course, if your name is intended already to trade on someone else's popularity, then that's a red flag. Question?
Are there any broad descriptors that define that doctrine of famousness?
It's usually the question is there a what is that doctrine of famousness called? And it's really just fame or famousness in the law. In the statute, there's a presumption that if a mark has been registered for 5 years, that it achieves this famous status. But each country kind of has its own laws. And again, a lot of this is legal in nature. So sometimes it's not in a statute somewhere. It's just rights that companies get by participating in commerce. So good question. And that, unfortunately, some of these ideas relate to getting legal assistance, and it's not always totally clear. Yeah. Oh, go to the agreement.
Yeah, and then just if you want to let everyone know, we've got another breakout session in 5 minutes. So if you want to get as far as you can, and then like we said, we'll make sure that if people have questions, they can.
Okay. Yep, and we'll be around for a little while too. So yeah, feel free to or send them in, and we'll get back to you. I want to spend a little time before the end here on some of these types of agreements. So especially as you guys are getting formed and getting up and running as companies, think about, you've got a team of 4 people, let's say. You may be developing something valuable. You may be developing intellectual property. And one of the most common and effective ways to consolidate those efforts in a way that, to me as an investor, looks attractive is to form some type of entity. You can do an LLC, a corporation, a partnership. The choice of entity involves tax questions. It involves who has decision-making authority. There's a lot that goes into it, but it's a relatively easy thing. You can register an LLC with the Colorado Secretary of State by filling out an online form and paying a nominal fee. I think it's like $40. It might even be $50. Okay, it's $50 now. But that's not a whole lot of money just to kind of get this legal structure. What does this do? Like, if you're going to be forming contracts with other people as an endeavor, it allows you to limit your risk, right? As long as you follow the rules of companies, it allows, if something goes wrong with your software or your company, or you have an agreement that goes wrong, that means it stops